Somewhere in the cold Atlantic, between the coast of Maine, the far northeastern corner of the United States, and the coast of Canada, there is a bare rock of about 20 acres. 20 acres means this: you can walk from one end of it to the other in about 5 minutes. One lighthouse, no trees, a few thousand nesting seabirds. And right now, at this exact moment, 2 different countries officially claim it as their own territory. Not 100 years ago, right now. That is the complete, verifiable fact you are walking away with in the next 30 seconds, whether you watch another second of this video or not. The United States and Canada, 2 of the closest allies on the planet, have never resolved who owns this island. But the real answer for why is far stranger than a modern argument. It has nothing to do with anything happening today. It comes down to a single sentence written by a Scottish nobleman 400 years ago who never once set foot on the island in question, and who never defined the one word that would end up confusing 2 governments for centuries. Here is the road in 5 steps. First, the sentence itself, the 1621 document where the problem was born. Second, the treaty that copied the problem instead of solving it. Third, the commission created specifically to clean up this map and what it did instead. Fourth, the lighthouse that changed everything without saying a word. And fifth, the legal principle that explains why a dispute like this can simply run forever, and what that means for the fishermen who are out on that water this morning. Before the sentence, you need to picture what it created, because 2 countries both claim an island is a strange thing to picture on its own. Picture 2 people who both claim to own the same house, and both are holding what looks like a legitimate key. Neither key is obviously fake. Neither person is obviously lying. That is what a sovereignty dispute really is. 2 governments, each holding a document that looks valid, each insisting their key is the real one, and nobody able to prove the other key is forged. In 1621, a Scottish nobleman named Sir William Alexander received a royal charter, a legal document from the king, granting him land to start a colony in North America called Nova Scotia, which is Latin for New Scotland. Alexander himself never crossed the Atlantic to see the land he had been granted. His colonial venture struggled for years and was eventually abandoned. But the paper he was given outlived the colony by centuries. That charter described the new territory's borders with this phrase: all the coasts, islands, and seas lying near to or within 6 leagues of the mainland. A league, at the time, was a distance of about 3 miles, roughly what an average person walks in 1 hour. So 6 leagues is a precise number, about 18 miles, a distance you could check with a rope and a map. But near to is not a number at all. It is a guess dressed up as a boundary. The charter never says whether this particular rock counted as near the new colony. And that single undefined phrase, sitting quietly inside a land grant for a colony that barely survived, is the first domino in this entire story. Why does a 400-year-old land grant for a failed colony still matter today? Because the next major document that touches this island quotes the same unresolved question instead of answering it. That happens in 1783, more than a century and a half later, when the American Revolutionary War ends and the Treaty of Paris makes the United States an independent country for the first time. Part of that treaty has to draw a line between the brand new United States and what remains of British North America, the territory that will later become Canada. The treaty gives the United States every island within 20 leagues of its coastline, with one exception. Any island that is now or ever was within the limits of Nova Scotia is excluded. Read that again. It hands over everything except whatever was already someone else's. And to know whether this island falls inside that exception, you have to go back to the 1621 Charter and answer the exact question it left open. The 1783 treaty does not close the loop. It just repeats it in new words 162 years later. So, which country is actually right? Here is where it gets genuinely difficult, because both sides are reading the same documents and reaching opposite conclusions, and both readings are logically consistent. The United States argues the island was never officially part of Nova Scotia, so it falls under the new American 20-league rule of 1783. Canada argues the opposite. The island was already part of Nova Scotia back in 1621, so the American rule never applied to it in the first place. Same charter, same treaty, two different conclusions, and no third document that settles which one wins. Did anyone ever try to fix this? Yes, 31 years later, in 1814. That year, the United States and Britain end another war, the War of 1812, with the Treaty of Ghent. This new treaty does something important. It creates official commissions whose entire job is to go back and settle the border questions the old treaties left hanging. One of them is tasked with assigning the disputed islands in this very stretch of water, Passamaquoddy Bay and the islands around Grand Manan. And the commission does its job. It rules on those islands, assigns them, closes those cases. But this one rock is never even named in the proceedings. No ruling is ever issued on it. An official body created for the sole purpose of cleaning up this exact map finished its work and walked right past the island, leaving it exactly where it was. If words cannot settle it, can anything? 18 years later, in 1832, something physical finally happens instead of another document. The colonial government of New Brunswick, the British territory bordering the disputed water, allocates £750 to build a lighthouse directly on the island. It goes up in 1832, 2 wooden towers and a keeper's house, with the first keeper paid £130 a year to live on the rock and keep the light burning. And from that year onward, without interruption, there have been Canadian keepers on that island. Not for a decade, not for a century, for nearly 200 years, right up to today, when the light itself runs automatically, but Canada still stations keepers there anyway, and says openly that it does so for reasons of sovereignty. This matters because of a real principle in international law. Think of a farmer who moves on to an abandoned field. He fences it, plants it, harvests it, season after season for decades, while the person whose name sits on the old deed never once shows up. Sooner or later, the law itself starts treating the farmer as the owner, because ownership that is never exercised slowly stops being ownership. Legal experts call this acquisitive prescription. If a state occupies and administers a territory peacefully and continuously for long enough, the occupation itself becomes a claim to sovereignty, separate from whatever the old paperwork says. Canada never won the argument on paper.
It just never left. Is there a rule that explains why a standoff like this can continue indefinitely? There is, and it comes from a completely unrelated dispute on the other side of the world. In 1928, a Swiss judge named Max Huber, acting as arbitrator, a judge both sides agreed to obey in advance, ruled on a fight between the Netherlands and the United States over a different island entirely, Palmas, in what is now Indonesia. His decision became one of the most cited principles in international law. Huber wrote that when two states claim the same territory, the question is not who wants it more, and not even who has the oldest paper. It is which state can show the stronger title, and a continuous, peaceful, real display of authority over the territory beats an old document that was never acted on.
Now apply that single sentence to our rock, and everything you have heard snaps into focus. The United States holds old paperwork, the 1783 treaty. Canada holds older paperwork, the 1621 charter, plus 2 centuries of lighthouse keepers the United States cannot match. Neither claim is a clean knockout. And under the exact principle Huber laid out, when neither side has a clearly superior title, neither side is required to back down. The dispute does not need to be resolved by anyone. It can simply continue indefinitely, because international law places no deadline on a tie.
Does this only matter on paper? Ask the people who fish there. In 1994, geographer David Gray documented in the journal Geopolitics that this island sits at the center of one of several maritime boundaries Canada has never formally resolved, decades after these treaties were supposedly settled. In 2005, researcher Beverly Cook published a study in the journal Marine Policy describing how lobster boats from both countries work these same disputed waters under 2 different sets of rules at once, different seasons, different catch limits, enforced by 2 different governments in the same patch of ocean. She gave the situation a name, lobster boat diplomacy. And in 2009, legal scholar Ted McDormand pointed out something remarkable. This island and the small rock beside it are the only pieces of actual land, not water, land, anywhere along the entire border between Canada and the United States where a sovereignty dispute is still officially open.
Thousands of kilometers of border mapped and remapped for 2 centuries, and exactly 1 small island never assigned to either side. McDormand also gave the reason nobody fixes it a name of its own: benign neglect. Both governments know that formally resolving the question would force one of them to publicly lose, so it is simpler and considerably cheaper to leave the question exactly where it has always been.
And leaving it alone is something you have probably lived yourself at a much smaller scale. Think of an old, vague agreement between 2 business partners or 2 family members over whose name is really on a lease nobody bothered to update, or who actually owns a shared piece of equipment. Nobody rewrites it because rewriting it means someone has to lose the argument out loud. That is not laziness. It is a structural choice. Leaving the ambiguity alone costs nothing, while resolving it costs someone a public concession. That is precisely the mechanism keeping a national border unresolved for 400 years, scaled up from a family kitchen to 2 sovereign governments.
So after 4 documents, 1 lighthouse, and 1 international legal principle, what is actually sitting out there in the Atlantic right now? The same rock this video opened with. 20 acres, 1 lighthouse, staffed continuously since 1832. A few thousand seabirds who have never once cared which flag applies to them. And 2 governments that have never gone to war over it, never seriously threatened to, and never solved the argument either. Because a single undefined word written in 1621 by a man who never saw the place turned out to be strong enough to outlast every treaty written after it. If you want more stories about lines that exist only on paper, and paper that quietly rules the real world, subscribe and answer this in the comments, because after 400 years, the whole dispute fits in one question. America's key is a sentence signed in 1783. Canada's key is a light that has burned since 1832. Which key would you honor? The ink or the light? One word is enough: ink or light.